In the courtroom, I stand bold. Self-represent, watch the truth unfold. Yeah. Moorish knowledge, writs on hold. Gavel banging, but my plea is cold. Yeah. Law book stack, I'm my own advocate. Govern itself, they can't manipulate. Two, sovereign move, no attorney fees.
Peace. Barghani, Islam, Salam, Hetepu, Rahubat, Gino Lakoninani, Chief Noble Bandele Elamine, back again for another show with the Pro Se Moors. We got my brother King El Bay in the building. We ready to build again. This is episode 5 of Pro Se Moor. So, we're going to get in today. We're going to get into the common and statutory law. We're going to talk about one versus the other, all the whatnot, how to move, all that. Okay. So please like this video, subscribe to the channel, and please share. All right. So, like I said, we're going to get into that. I'm trying to learn how to do some stuff on this thing. So before we get into that, I'm going to, what I want to do is show a video. I'm gonna show a video ad on let's see if I can pull this up right. Do it right. I'm gonna add this commercial in, right? Just let y'all check out this commercial. And we gonna build after that.
Yes, knowledge is for the people. Get your books today on indigenous laws, or your one-stop shop for indigenous needs.
All right, y'all. So y'all check out our books. I got all our books. Me and King El Bay books are on Amazon, but they are also on indigenousmoors.org. All right. So with that being said, man, what's good, brother? What's good?
What's good, Chief? Back in the building once again. The Pro Se Moors. Dropping the knowledge on everybody.
Yeah, dropping it here. I know you've been busy, man. It's been hard to catch up. It's been a few weeks.
Influx of calls, people calling. That the dynamic duo back in the building.
Yes,
Former
sir.
a Pro Se lawyer, Moorish lawyer, former jurist.
Yes, sir. So check this. So what we was talking about getting into today, y'all, we're gonna be talking about common law, statutory law. A lot of people, understanding sovereignty, understanding the principles of law. We got to deal with that. We got to deal with what is common law, because we hear a lot about common law, especially, with sovereign and whatnot. They talk about common law, but what is common law? How is it to be used? Right. So, I got a couple of things, man. What I'm going to do is I'm going to throw this out here and then let you, feel what you want to talk, just stop me anytime and expound on whatever it is. I just put some stuff together for the day. So I'm going to blow it up a little quick. All right. So what I got right here, you can tell me how you feel about it. That's got common law. Common law is a legal system based on judicial decisions and precedent. It plays a significant role in the modern United States legal framework. Originating from English legal traditions, common law is characterized by the principle of, what's how you say, stare decisis, or decisis, which means that courts should follow previous ruling when deciding new cases with similar facts. It says this system allows for consistency and predictability in legal outcomes, which is vital for ensuring fairness and stability in the administration of justice. All right. So anything you want to say about it, or
So we got to remember when they talk about the common law, they're talking about the British common law, right? It's associated with the British common law of England, how they established this legal system and how it would flow. But you got to understand, okay, it's court made law. Who is the court? That's the Supreme Court, right? Just every body of branches of government who are Supreme Court, right? So we need to understand who governs the common law. The Supreme Court has bodied the common law. They have exclusive jurisdiction over the common law because it's judge-made law. So when you're dealing with common law principles and understanding that when we talk about principles of law, it gives birth to the rules and construction. The principles of law is the pillars in which the system works and flows. So we're talking about a common law system that is regulated by common law principles, in which the Supreme Court make all the decisions on a common law issue. So we got to understand. So a lot of times when you get in the court, if the court don't charge you with a common law action, right? Let's say fraud. They got statutory fraud, and then you got common law fraud. If they don't bring in the original complaint, it says common law fraud, and they charge you with a statutory fraud, then they can't come back and charge you and say there was common law fraud because it wasn't a part of the original complaint.
okay,
So we got to understand these rules based on these systems that come into play. But I'm gonna let you go ahead and do the rest of your spiel before I unleash the cat out the
yeah,
bag.
yeah. You know, I already. Hey, look, you know, y'all know King L Bay, man. He really be running this stuff down. He really get into this, so you know, it's a lot to it. Um, so I just want to, you know, get everybody to understand what common law is real quick before we jump off. A lot of people don't really understand common law. So it's saying that in the United States, common law operates alongside statutory law, which is created by legislative bodies, and regulatory law, which is established by governmental agencies. Courts often rely on common law principles to interpret statutes and regulations, filling in the gaps and resolving ambiguities. For instance, in tort law, which deals with civil wrongs like negligence, much of the guiding principles and rules have been developed through common law. Judges look to past decisions to determine the outcome of cases, thereby evolving the law based on societal changes and new contexts. All right. So, um, like I said, I mean, common law is still being used in America. A lot of times we don't understand that. I mean, but it definitely plays a major part in what is going on in the United States right now. Um, okay, so with that being said, right there, brother, is there anything you wanted to add to that, or anything in that you wanted to expound
Right.
on?
So let's check the common law. The United States is based on two aspects of law: the civil law system and the common law system. Now, the civil law system is based on Roman law. It predates common law, right? So the civil law system is based on Roman law, statutory law, which is ran by legislation. If you look at Rome, what was Rome? It was a republic. We're supposed to have a republic form of government. That means that the people get to vote and establish the laws in which they want to live by. So the form of government supposed to still be the republic, but the principles of law at hand, based on a common law system and a civil law system, we need to understand and make clarity. Because the common law, right, is based on the principles of law, while the statutory law is legislative law that need to be followed, in which the people are supposed to elect into legislation by our what? Representatives. So we need to understand what is the difference, what's the contrast, what's what, so that we can better articulate our arguments, being precise in our court cases. So you need to know the difference. So if you're charged with a statutory code, then the court can't, like I said, can't come back and then turn around and say, we're going to hit you with this common law crime, because whatever the charging instrument, it has to identify what you charge it with, or they're not affording you with due process. Due process is one of the elements. You have a right to confront your accusers. You have a right to be heard. You have a right to make a defense, but you also have a right to know the charges, the nature and the charge, according to the Sixth Amendment. You have the right to know the nature and the charge, according to the Sixth Amendment. This is a constitutional question that has to be answered. When you understand the constitutionality of your case and your situation, if you don't, then you don't know what to look for and know what to ask based on these common law principles associated with the Constitution. The Constitution only gives you 4 categories of law or jurisdiction in which they identify. It's common law, it's admiralty, maritime, and equity. Those are the 4 jurisdictions, right? But they're a form of republic. So it's supposed to be a republic based on a common law system. The statutory law, right, is not a jurisdiction in which is identified in the Constitution. So the statutory law is a part of a caste system in which they then deem the people who are operating under this caste system as black and white people.
Okay. Okay. I got you. So, um, okay. Y'all check. I'll say. I'll say. All right. Um. So, all right. So this next like I want. Okay. So whatever I'm in this next paragraph, I'm gonna see. Where you break down this paragraph. This next paragraph. Okay. So it's saying that what is it? Furthermore, it's talking about furthermore, common law influences such areas as contract law, property law, and family law. For example, in contract disputes, courts may defer to precedents to determine whether a valid contract exists and how to interpret its terms. It says, despite the rise of codified laws, now this is important to me. I mean, this is what I feel important. It says, despite the rise of codified laws, common law remains a dynamic and integral part of the U.S. legal system, serving as a foundation for legal reasoning and ensuring that the law adapts over time. This blend of precedents with new legislative measures creates a robust and flexible legal environment capable of addressing contemporary issues. Now, before we get into that, I just wanted to look at this real quick, right? Uh, I just wanted to look at this where it said that even though we talking about statutory law, and despite the rise of codified law, common law remains a dynamic and integral part of the U.S. legal system. So, what right there? What do you think about that statement, Brother King? You on mute?
My fault, everybody. The common law is what the system is reflected in the Constitution. Under Article 3, Section 2 of the Constitution, it identifies that it's a common law system that also have amity, maritime, and equity, right? So the systematic place of civil law, like I said. So when we looking at contract law that influence the areas of everything, if you ever know me, I talk about contract, contract, contract. Why do
So
I say that, right? Everything you should have in accordance to a contract and a trust to build a relationship that sets a common law precedence based on the contractual relationship of the two parties. So, what is contract law embedded in? What is these things family law embedded in? In certain circumstances, it's embedded in what? Private rights of actions. Parties under these actions, under contract and property law and family law, these are private rights where parties get to then create what kind of circumstances they want to be in based on contract versus based on statutory authority by legislation. So I have a right to then create a contract on how I want to be married, how I want to, what I, if I want you to buy or sell my car, I can put conditions on that. I can put valuable consideration. These are elements of common law principles that's going to deal in contract. For if you sell of your house, I can do a land contract. I don't have to go to the bank. I can say, well, I'm gonna sell you my house on a land contract, and you pay me this every month. Con-
okay. Hold
contract,
on. So let me ask. So you saying that land contracts are really part of common law,
yeah,
or okay,
it's 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 based. So I want you to think of contract law and property law. These are private rights of actions. So a contract can be oral, a contract can be written. These are contracts, but you got to have evidence of the contract. And the best way to do everything is put it in writing. So if we put everything in writing, right? Because once you create a contract in writing, you can't then go back and say, well, I had an oral agreement. It must stay in writing. So if we ensure the integrity of what we're doing, we should be living our life based on private rights of actions, dealing with the estate planning process, dealing with contracts, so that we can protect our private rights and that we don't have to be scrutinized under certain instances by what? Statutory authority under the civil law.
check. Ashe, Ashe. So all right. So looking further when we on this, look, it says so. It says common law, also known as case law or judge-made law, is a significant aspect of the legal systems in many countries, including the United States, the United Kingdom, and other Commonwealth nations. Now that's interesting because the Commonwealth common. So this is it is developed through decisions made by judges in court cases where legal precedents are established and followed in future cases with similar circumstances. Today, common law continues to evolve through judicial rulings and remains a critical source of legal authority. One of the key features in common law is its reliance on the principle of stare decisis or decisis, which means to stand by things decided. This principle ensures consistency and predictability in the legal system. Okay, so uh, let me go down here. So in recent years, I want to talk about this. In recent years, common law has played a crucial role in shaping various areas of law, including contract law, tort law, and property law. So let me ask you this before I go any further. It's talking about contract law. We talked about that just briefly. But what do they mean by tort law?
Tort law is where someone can claim damages or injury, right? Based on a breach, based on willful neglect, personal injury. There's a there's a list of tort law actions that you can take. So it's a list of those things. So based on the application of law, based on the tort, if it's a personal injury claim, if it's a breach of contract claim, whatever the claim is, you got to meet the standard of operation for it's that contractual or that application in which you what we would say and meet the merits of such identifying that argument based on the facts and findings of the case. And then the court will apply the law based on the application that you presented. So we need to understand how this stuff works under tort law because the tort law is going to be your law to give you remedy when you're injured, right? Especially in
Gotcha.
your private capacity.
So, so if okay, so tort law. When we talk about tort law, we're talking about it kind of falls under common law as well.
Yeah, it files under common law, but 9 times out of it's gonna fall under common law principles.
Okay, check there. So y'all got that, Ashay? So okay, so with that being said, so it says, for instance, landmark cases such as Donahue and Stevenson have established foundational principles of negligence law, while cases like Carlisle and Carbolic Smoke and Ball Company have defined essential elements of contract formation. Common law also intersects with statutory law, where judicial interpretations of statutes can influence their application and development. As society continues to evolve, common law remains a vital component of the legal landscape, ensuring that the law adapts to meet the needs of the present while upholding the wisdom of past judicial decisions. So, um, so what when I'm looking at this too, I see that common law is still very prevalent in society. And the reason why I say that is because I don't know if you guys, but many times when we've gone to court and we try to use common law as a remedy, they often try to shoot it down, right? And they try to act like common law is no longer used. And they try to force us into using statutory law or statutory, principles. So, what I'm hearing and what I'm reading is that common law is still very much alive. And it's the backbone of even all the stuff that they're doing. It's the backbone of statutory law. You still have a lot of the principles of of common law, embedded deeply into the legal system. So I don't know if you got anything to say on it with that. You are muted.
So I want you to think about jurisdictions and who got control over these jurisdictions when we talk about the constitutionality of these courts and what they based upon the authority granted by the Constitution, what they can do. So when you think about civil law, I want you to think about Congress. When we think about common law, I want you to think about the Supreme Court. So we dealing with issues based on principles of law once again. So the Constitution, right, granted Congress the authority to create an inferior court, right? An inferior court based in civil law. It's all about civil law. These laws um is based in that. So when we talk about the court, the government being a democracy, right? Where's that coming from? Where's that undertone coming from where we are democracy, where it's nothing in the Constitution that say we're democracy, it says we're a republic. It said we're a Republican form of government. And a Republican form of government is where the people are pretty much the sovereigns. And they do what? They control government. Government don't control them. Government don't get to pass laws that regulate how people do certain things. But now, based on this democracy, right, meaning Bob rule, right, where did that undertone come from? Where did that context come from? It had to come out of the civil law principles, this Roman law. The Constitution never says anything about statutory law. So a lot of
Nope.
us talking about the 14th Amendment. So statutory law is based for what? Artificial persons, status, right?
I hear
Common
you.
law dealing with property law, family law, private law is dealing with the common law system, dealing with contract law. So this is why you need to understand trust, understand the importance of contract law, because this is not rooted in a civil law system based on a caste system. So as we start to thinking about nationality, we start thinking about all of these different things, right? We need to understand how it relates to everything that we're doing with the court. Why is nationality so important? Because their civil law system is based on artificial classes, the artificial class of people associated with a civil law system. So they had to create, what do you do with people who flood your country and they don't have a nationality, they don't have a nation because they abandoned and left their nation for whatever reason. What do you do with the people? You have to sometimes put them in a class, right? Because they could they become a part of your nation technically, because sometimes nations have certain rules, right? Some nations say that the woman carries the bloodline and to the nation dealing with property. Some nations say the father, right? It depends on the scope of what you're doing, everything. So we need to understand the system so that we can understand how to create balance and utilize this information and stop misappropriating the law. Because, like I said before, the legislative branch deals with what? The civil law system. It's not even identified in the Constitution. It says that
Right.
we are a common law republic. It don't say nothing about civil law.
Okay. You say it don't right. It don't say anything about civil law.
So where's the civil law coming from? It's coming out of the aspect of what?
Hey,
Out
I
of
got something to I got something to read on that too. I got something to talk about. Go ahead. Go ahead. I don't want to. I mean, I'm my fault. Go ahead.
I'm a bust it down. So what? So when we're dealing with this under contract, right? We need to understand where's it coming from. It coming from admiralty, admiralty, admiralty. It's 4 jurisdictions. Remember, it's 4 jurisdictions based on the categories. 4 jurisdictions: common law, equity, maritime, and admiralty. It's so easy.
I got you.
So
But check.
how?
All right. So, go ahead.
Well, God,
I wanted to because we were talking about civil law, right? And it was something that I saw regarding civil law, right? And I wanted to read this. You might find this interesting too. I'm not sure how much you know about this, right? But it says it's called common law, civil law traditions. So it says most nations today follow one of the 2 major legal traditions: common law or civil law, right? It says the common law traditions emerged in England, right, during the Middle Ages and was applied within British colonies across the continents, right? Then it says the civil law tradition developed in continental Europe at the same time as common law, right? And it says it was developed. I mean, it was applied in the colonies of European imperial powers such as Spain and Portugal. So now I want to stop real quick, right? Because we don't. We was talking about civil law and common law, and we were saying how civil law is really not in there in the Constitution or whatnot. But what is interesting is that civil law was in the continental, what we call the continental United States already, because you have French or Spanish and Portuguese that had already came to America prior to England. So those civil law systems were already in the United States, right?
right?
So there would be, it would make common sense that you start seeing civil law creep into common law, because we got common, like we got a lot of civil suits and things of that nature, which is not part of necessarily common law, but is more part of tort law. But the civil law is coming out of um, civil law comes out of the other part of Europe. Like, we got all these colonies around the world, and all of them are not British. We had the Spanish and the Portuguese were superpowers before Britain became a superpower, right? So the first Christopher Columbus sailed for Portugal. So Portugal and Spain were already in the United States. They were in Central and South Americas at the same time. So I think that's where the civil law come in when we talk about civil law. It's really not really part of British law, but it's part of Europe law. You see what I'm saying? It says, because it say right here, civil law was also adopted in the 19th and 20th centuries by countries formerly possessing distinctive legal traditions, such as Russia and Japan, that sought to reform their legal systems in order to gain economic and political power comparable to that of Western nation states. So I just wanted to bring that up, man. I don't know if you got anything to add to that particular understanding, what they were saying.
Well, I want to come in a little bit of contrast because I got context that the civil law it predates that. It was Roman law, and even before that,
Right.
it predates Rome. The common law system, right, is an ancient system. Also, it predates Great Britain. Uh, They didn't establish anything. What they did is adopted these things, right, and put them into formation. So this thing about what they established. Now, you got to remember, that the Europeans have what they have the European Union under treaty, right? So they came together because what people don't know, the lands that we stand on today are still governed by treaties. It's still governed by treaties. And that certain European powers still have jurisdiction. France, Spain, Portugal, Great Britain, right? Still have rights to lands based upon treaties. So wouldn't you believe that if France have a civil law system, that the civil law system would eventually creep in if they have an international agreement under treaties as it relates to the United States and the United States maintaining their authority as trustees for these major powers, European powers? So we got to understand, how did the civil law system creep in and now it became a democracy?
Yeah. I mean,
It
okay,
came through these
think
European relationships and it
right.
crept in.
You gotta think about it. America was allies with France, but you know, when you got okay, if you got the Spanish that are like the Spanish took over like what they call like New Orleans and all that area, the Louisiana Purchase. That was originally Spanish. So those laws originally you know, before France or the United States owned it, it was under civil law systems because it was Spanish. So I could see like, you know, as America take over that area, they kind of continued the civil law system would continue, if you will. That's just my thoughts on it, man. I mean, I'm not trying to, but I could see why the civil law was around and how it could have been adopted into an American system because there was parts of America pre-colonial that were already under civil law in America.
Exactly. Exactly. So, but if you look at the Constitution and how it's constructed, it don't talk about civil law.
Right. I got you.
You see what I'm saying? So the Constitution. So how did they usurp the Constitution and bring in a democracy and bring in civil law?
Huh. I got you. So look at this. So when it talks about common law in here in this, it say that common law is generally uncodified. Would you agree?
Yes,
Okay. And it says that this means that there is no comprehensive compilation of legal rules and
exactly.
statutes. While common law does rely on some scattered statutes, which are legislative decisions, it is largely based on precedent. So we talked about that, but uh, the fact is uncodified. So it's almost like statutory is the opposite of common law in a sense, and almost like they in contrast of each other, but yet they're rooted in. It's like it's the contrast of common law, but it's rooted in common law. If that makes any sense to you.
Yeah, because even though the system is they incorporate a civil law system, it's still based on what principles of law that is a, that is found in the common law practice, doctrines, legal doctrines. Those are principles. So these principles are embedded throughout the system. So in the Constitution, it said Congress only has the right to write laws, right?
Right?
So, so what did this say about the common law?
What you mean?
What did you just read? It said it's generally what? Uncodified. It's judge
Right,
made law. It's not
right,
written. The
right,
common law is not written. So the
right.
Supreme Court, it only dealing it was institutionalized for the common law practice. So what was Congress there for? It was there to write the civil laws, right?
Would you say it was
It was
written for the
there, it was
civil
there,
laws or statutory law? Was
civil law
Congress
is statutory law. It's a civil
okay?
law system. Civil law is statutory law.
Okay, well, okay. So break that down. How is civil law statutory law?
Civil law is statutory law on the common practice that it was based on codified law. Codified law is and statutory law is just another name for codified. Civil law is nothing is it's identified as codified law, and statutory law is codified law.
Okay, I can see what you're saying. I mean, because there are civil. So okay, so let me ask you this, because you're talking about codified. So we're talking about like United States, the USC, right? That USC is statutory law, right?
Right? But you got states that have statutory law.
Right. I mean, each state, as y'all want to know, each state is or has their own codified law. Like in Ohio, we're in Ohio. Ohio has Ohio Revised Code, so that's codified law, right? Check.
Right.
All right. So civil law and statutory law are codified laws. So now we've been talking about a lot about common law, but what about statutory law? Right. Uh, let's look at statutory law and see what you got to say on that. That we can. So it's saying statutory law, the definition. Now this is on Library Highline College. All right. So it's saying statutory law is law established by an act of legislator that is signed by an executive. For federal statutory law, the acts are passed by Congress and signed by the President of the United States. For that law, the acts are passed by the state legislator and signed by the state governor. Okay, so pretty simple. This is kind of interesting, though, in my opinion, because it's saying that state law, let me go back there. State law, statutory law is law established by legislation, but signed by the executive. So so really, like statutory law is dealing with the other two branches of government, where common law is only dealing pretty much with one form of government, which is the judicial branch, right? So common law is built in the judicial branch of it, where statutory law is dealing with the legislative and the executive branch. Is that
Well,
you got anything to say?
so they call that regulatory law, right? That the agencies can regulate law, right? But nothing in the Constitution ever states that. It's a constitutional hiccup, an error in law. It's a conflict. So um, I want us to understand that the United States, based on the civil law principle, the civil law system, um, what is the civil law exactly for? When we're talking about color of law, it's dealing with artificial persons. It's dealing with artificial constructs. That is what the statutory law is for. It's not for dealing with individuals who are exercising private rights. It's dealing with artificial persons in which Congress got jurisdiction. So the civil law slash statutory law is made for artificial constructs because it's dealing with inferior courts who are have an inferior position to the Supreme Court, who has original jurisdiction to hear cases under the common law. While civil law matters are deal strictly under the congressional body, then who was enforced under an Article 1 tribunal, right, dealing with the administration of justice as it relates to your case under a code. We must learn how to discern this so that we can start better maneuvering with this information.
Check dig. So I was just looking, right? And I saw this. So we was talking about, like it started the United States started out with common law, and then it became statutory law. So I just seen this, right? And so we just like, well, when did it happen? So it's saying that the statutory law, the USC, the United States Code, it said it was only in the 1870s that the first codification of federal statutes was approved by Congress. The predecessor to the U.S. Code, first published in 1875, is known as the Revised Statutes of the United States. So I just wanted to show everybody, um, that statutory law is not. It's almost it comes after 100 years of the United States. So the United States, as we know, basically in the 1776, all the way up until 1870 something. So roughly 100 years, the United States was predominantly under common
It
law.
was a common law system. It wasn't a statutory system until 100 years later.
Exactly. Exactly. So I just thought that was interesting. Uh, but so I mean, go ahead, brother. I don't know. I mean, you got anything else to say about it? Or
I'm just saying when we like I said, the statutory law is based on a caste system. It's for black and white people. It's based on a caste system. It's based on artificial persons. Art official. So
okay,
it's an art, right?
right,
So author, art official.
right. So
So
would you say that would you say statutory law uh, was created out of the 14th Amendment, right? Because you're talking about artificial persons, right? And okay, the 14th Amendment, were they the ones that created artificial
yeah,
persons, right?
right.
Okay, so based
Well,
on that,
it wasn't. I think
okay,
it was after the. It was. It was after. I think it's the Thompson versus Railroad case that they argued that right now that set a precedence for artificial persons to have rights. So now that introduced the lane for the artificial person argument, in which a lot of people are starting to look at. I mean, which everybody started to look at is now you got corporations that now have rights as well has rights as much as a human being based on these codes. So they got rights. You got civil rights, right? Corporations have civil rights. Black people were granted civil rights, right? That's why it was like in the Dred Scott case, a white man has has a black man has no rights that the white man have to respect because why? He was an artificial construct created by Congress under a caste system in which he was going to be in a permanent inferior position, right? That's why nationality was so important because it brings you out of that caste system and puts you back in a system of law in which is governed by international relations based on treaties, based on those things. So it's under contract, right? This is what a lot of Moors got to understand. We can enforce contract as a nationality, as a group under a nationality. All you got to do, declaring your nationality is one thing, but contracting into a group based on how you want to be identified, you can enforce that under a common law system, under a common law contract, under common law
Exactly.
practice, right?
Exactly.
So
Exactly.
this is what we need to understand under this, under relationship, and then pull yourself out of the statutory thing because you got to understand you can have a group who identify as a particular nationality own a corporation, right? Own a corporation, right? That's associated with a trust, that's associated with certain things. So my job is to teach and help people understand how to utilize contracts, how to put the common law and the civil law in proper perspective, looking at how they operate, pulling yourself out of that nationality void under contract. So
So,
we got to
uh,
look at contracts. We got to always go back to contracts. So if we want to deal in a common law system, we want to revert back to the contract, right? The private rights of actions dealing with contracts, dealing with estate rights, rights of the estate. It's called estate planning.
check. Exactly. So, how to invoke common law in the court system, because you can't just go into the courtroom and say, I'm under common law. People go in there and say, well, this is common law. How am I fighting this? And then I'm under common law and you got me in this court. But to invoke common law is to use contract law, is to use trust law, estate, and use estate planning. Is that what I'm hearing from you?
Yes,
All right,
yes,
y'all get that? So when we talking about common law, y'all don't go in the courtroom screaming common law. Like you have to invoke it by using the principles of common law that are still used in the courtroom. Because
exactly.
they will try to fool you and make you think that you got to use statutory law. But the common law, as we've read, is still there. We're still under common law. So um, predominantly contract law. Uh, Brother King L. Bay has been, discussing this part about the contract. Contract. Me and him always talking about contract law, and that, like when we were looking earlier, we were looking at a case, and so you guys can look this case up. Carlisle versus Carbonic Smoke Ball Incorporated. This 1892. It was saying it's a foundational case in contract law, particularly within the common law tradition. it deals with several key elements of contract formation. So they're talking about offer, acceptance, consideration, and intention to create legal relations. Right? So it's saying that in the first the case elucidates what constitutes an offer. So the smoke ball company placed an advertisement promising a reward of 100 pounds to anyone who contracted influenza after using their smoke ball as directed. The court held that this advertisement was not merely an invitation to treat, but a unilateral offer to the world at large. This meant that any person who performed the conditions stipulated, using the smoke ball as directed and subsequently contracting influenza, would be entitled to a reward. The specificity and deposit of 1,000 pounds in the bank to show sincerity indicated a clear intention to be bound by the terms of advertisement. Okay, so I don't know if you what do you have to say about that, my brother?
So,
Or anything. I don't know.
right. So what they did was they made themselves contractually binding by performing what? All the elements necessary to bind yourself. So what is the condition of binding contracts? The any party, you got two parties. If any party perform any element of the contract, they just stimulated the terms and conditions of the contract because they acted in good faith to perform it. Now you can't we can't or retract to say that wasn't my intent when you clearly put it out there under a unilateral agreement, making an offer to the world that hey, if you contract the influenza, we gonna put this $1,000 in the bank, and we're showing our sincerity. Now you remember I talked about the word sincerity as it relates to court. Remember we talk about sincerity as it relates to religion, right? The court want to see sincerity. What do that mean? What they mean by sincerity? They want to know if you fulfill any of the obligations of the contract by either signing it or performing any of the things in the contract. So now the court can say he's sincere about what he did because he's acting upon what he agreed to do. If you don't, you can't say I'm this and I'm a Muslim, I'm this and that, and you're not acting upon any of the contract or any of the things according to that faith or according to that thing, and you're saying that you made a pledge, and nobody has said that you have done that. The court is not going to look at that as sincerity. So if you, like for example, let's say you smoke marijuana, part of your religion, and you get pulled over, and the police charge you for possession of marijuana, right? You saying that this is a religious herb for ceremonial practice. You can make tea. They don't know what you use it for. You don't have to ingest it. You don't have to roll it. It can be used for medicinal purposes, right? It can be used. But where's the contract and where's the religious body that support that that's what y'all use it for? Where's the information or the stipulation? Now the court got to go back and reach to the presidents of common law, stare decisis, and look at something, or either set a new precedence or look to an old precedence based on something that's not based in the civil law, based on the substantive language in which is being used by the statute, and determining your status if you're not in a particular statutory category based on your status by associating yourself with certain institutions that put you under this statutory or civil law. Do that make sense, Chief?
Ashe, if y'all make that makes sense, y'all drop a one in the chat room. Y'all drop a one in the comments. That
One,
makes
two,
sense.
three to the four.
All right. So um I was looking at when we were talking about civil law, right? And in the article that I had been reading from already about common civil law, it made a comment, or there's a paragraph or so dealing with how did civil law get into the United States. And I just wanted to bring that back up just to clarify some things. So it says here that the American legal system remains firmly within common law traditions brought to the North American colonies from England. And it says, yet traces of civil law tradition and its importance in the hemisphere may be found within the state legal traditions. Ooh, this is interesting. Within the state legal traditions across the United States. Most prominently is the example of Louisiana. And that's what I was talking about, right? It says where state law is based on civil law as a result of Louisiana's history as a French and Spanish territory prior to the purchase from France in 1803. Many of the southwestern states reflect traces of civil law influence in their states' constitutions and codes from early legal heritage as territories of colonial Spain and Mexico. California, for instance, has a state civil code organized into sections that echo traditional Roman civil law categories pertaining to persons, things, and actions. Yet the law contained within California code is mostly common law. So so to me that it made more clarity on uh why we have civil law in the United States. So what it's saying to me is that it mostly comes from state law that has
So,
adopted prior colonial powers that were there have influenced their state law. So so you
so
go ahead, my brother.
I don't want you to think of state as 50 states. I want you to think on international law terms as a state, right? A country, France. That's a state. So you had international law come in because it wasn't a part. They were all different states sitting over here. And through the Louisiana Purchase, right? Because I don't want you to think purchase mean they bought it. Purchase based on an agreement to manage and operate that state. They had to keep their what? Civil law system intact. So you got California, Spain, that also was another country under the civil law, utilizing the civil law system. So you talking about California, Mexico, and them southern Texas, they're they're engulfed in civil law systems because Spain was present as an international state. So when they all came together on a treaty, what they did was incorporated the civil law with the British common law and made a new mixture of a system, associated the common law and the civil law together based on the both European influences that now what we appear to see today. You see what I'm saying?
I got you. I got you. Okay. So that is okay. So that's interesting, right? That's interesting. Uh, so I don't know. I mean, okay, so what else? What else you wanted to build on with this, brother? I mean, like
Let me
I got a
see.
couple other things to build on, but is there anything else that you wanted to like
I,
expound
I,
on
I
as far
think
as
we
this?
need to understand jurisdictions. Who has jurisdiction and how this stuff works so we can keep everything in the context of jurisdiction dealing with these matters, right? When you think, like I said, when we think about the civil law, we must think about Congress, right? We must think about how Congress have the authority. Based on that, based upon the construction of this Constitution, they gave Congress a particular right or authority to exercise the civil law. And then in the common law. So a lot of y'all, when y'all argue your cases, right, based on status, y'all be talking about, man, I'm my status in this and my status in this. You go get social security numbers, you go get EIN numbers, and now you engulf yourself in a civil issue dealing with a prescription of law based on civil law created by Congress, not a common law issue that was created by contract. So most of y'all don't know how to contract or create a contract which then embodies a particular relationship. So when we think about jurisdiction, I need y'all to understand how these things work so you can stop putting yourself in situations or predicaments and you don't know how to handle it. Because y'all, like I said, y'all go get social security numbers, go get EIN numbers, but then you start talking about, well, I don't got to pay taxes. Well, I ain't got to follow the laws. But you got an institution that has been incorporated that's identified as an artificial person that is subject to the United States laws or the laws of the state. And you don't know how to deal with that because you're not understanding estate planning and contract law, the legal system itself. So you make all of these grave errors and you get mad when you get smacked over the head because you can't understand these principles. So you must understand how this stuff works to be able to navigate. That's just like having a compass and learning how to read a compass and learning how to sail the seven seas so you don't end up in areas that you don't know how. You never end up in a place you don't want to be, where you're in an enemy territory or you're being chased by cannibals because you landed in a place where cannibals live because you didn't know how to navigate and use the stars and the compass properly. That's the same thing. You guys don't understand the system and the concepts of the system and the principles that govern the system. So you go and make up these processes that's frivolous and has no merit and no legal basis because you don't know how to critically think about the whole system at hand and the process of the legal system that is working simultaneously. You don't know how to figure it out. So now you're stuck in limbo because you believe a process is supposed to work and you don't even know the legal principles in the legal system in the formation of how this is supposed to work.
Okay, so uh, so my thing is this with that being said, you're saying that a lot of people that are studying, that's Moorish brothers, people who are so-called sovereign, their application of certain procedures they're using are not being effective. And for me, when we're looking at common law,
Procedure. This say
uh,
processes. They're not using procedures. They're using processes.
okay, I mean processes. Um, with these processes that they're using, um, now that we're looking at common law in this perspective, what he's saying is that these procedures that you guys are using, or these processes that you're using, you don't have any like valid reasoning.
It don't have any legal basis.
Right. It's not like if you're trying to invoke common law, it has no legal basis. So, a lot of time, like we haven't looked, like we didn't look at common law as civil law or as tort law. We haven't looked at these things that way. We think of common law as this thing on the side, like this way of life that England brought to the United States, and that it stayed that way. It stayed in that form. It's like some ambiguous law that you can pull out of it and try to use it to get you out of driving and this and that. So my thing is this, like, for example, if we're talking about drive or operating a car or whatever, and we're trying to keep it in common law, how would we keep it in common law? In your opinion? And by the way, peace, brother. Peace, peace. Glad to see you on aboard. Now, are you there? Okay, I think he had to do something real quick, man. I don't know, but I'm thinking when he's talking about, like, for example, if we're trying to drive or travel in our vehicles under common law, that was my question. How would we do that? And what he's saying is that common law, if we want to stay in common law, then we got to use contracts. We would have to use contractual agreements. We would have to use the basis of trust law, estates, like estate planning. These things to allow us to stay within common law. So instead of you going in there in court and trying to recite particular law, like particular case law that are outdated, as that's how you're trying to stay in common law, that's not going to keep you in common law because you're citing old case law. But what would keep you in common law would be contracts. So I was just trying to expound on that, brother. What my question to you was, how do you keep, like, if you're driving or traveling or any of these things, how would you keep yourself under common law and be able to bring that into the court of law, if possible?
So if we're dealing with aspects of understanding traveling and driving and stuff like that, under conventional wisdom, we got to understand that we got to look at the contracts that we're under. So let's talk about this, right? Because these are unspoken things that we need to talk about. The selective service. A lot of you guys are in the selective service and don't even know it. I was just talking to a gentleman the other day. He looked himself up in the selective service, and he's in the selective service. That's a contract. A lot of you guys go get a driver's license. Do their application of the driver's license, they sign you up for selective service. A lot of people don't know that. So you have to look at that. Now you are under contract under this status of the selective service. You got a social security number that is being used as what? A internal revenue number as a what? A, a tax identification number, because you're signing up for these things in order to utilize these benefits associated. So you have to understand how to formulate the estates and use these rights under the estates to contract. And these contracts, you create maybe an agency or entity that then create other corporations in which may utilize and hold private property. Now you keep that. Now you keep the contract in place because they're holding private property for an exclusive right or purpose in which you can identify through contract, eliminating certain things and rights associated with that. So you might say you want to operate a vehicle, right? Um, Under that. So what do it tell you? Because we got to go back and look at what's going on as it relates to certain things.
Right. I just wanted to show this real quick because you said you made mention of this. You said that
Right.
under the selective service. So under our this is under Ohio rules. Every application for a license shall state that submission of the application will serve as the applicant's consent to registration with the selective service system, if so required by federal law. So I just wanted to say that. Um, and I got a brother that made a comment. Brother, I want to say Alim or Alhim Bey. It says that the key is to understanding what jurisdiction of the public you are operating in. You have to invoke common law by putting contracts on the public record, i.e., affidavit of corporate denial, etc., etc. All right, brother. I'm gonna let you um, expound on that comment. What do you think about that comment, my brother?
Um, well, he said you have to understand what what jurisdiction of the public you are operating in. If you're in the public, you are in the public. You're in the public domain. So they got supreme authority over their jurisdiction. So if you get out there, you can't then turn around and say, I'm gonna use common law. You just embrace yourself in the public, right? A contract is not, if you incorporate in the public, you get a corporation. That corporation cannot turn around and say, well, I'm not incorporated in the state. I'm not an LLC. You incorporated under the laws of the state. So this is what I'm saying. We must understand how to properly use the proper terms and language associated with what we're trying to accomplish so that we won't get things confused. So we got to remember the public is the public and the private is the private. They don't mix. So what do you mean they don't mix? They can contract, but they don't mix. Mixing is where you commingling, um, you going in and commingling. You took yourself out of the private and put yourself in the public jurisdiction. And that's just what it is. So you can have a trust. You can create a trust. You can operate everything by trust and put it on the record. Okay? But you might need an entity, right, that needs an EIN so that you can get let into the public. But you got to understand how that operates. This is why I teach estate planning so people can know how to properly understand how to move about with this information. I yield, my brother.
Shay. So, so the other part of that question, he was saying that you have to invoke common law by putting contracts on the public record. So, what do you think about that aspect of it?
You don't have to inform the public of anything. That's why it's called private. What's another word for private? Secret.
So, what I'm saying is, okay, so he got another question I'm gonna put up there, y'all, brother. So, what? Okay, so what I'm saying, what I'm hearing him say though, you have to invoke common law by putting contracts on the public record. So, possibly when you are in court and you're putting you're putting it on record, right? Is that not public record? That's not public record, or
Well, this is the thing. You can ask the court. You don't supposed to put it into the pub. It don't supposed to be made public record. When you bring private contracts into that, you ask the court to conceal these records because it's not for public review. So if I got a private contract between me and you, it's not supposed to be disclosed for the public. So you put in the motion to seal, and that private contract becomes sealed, concealed from the public view, and it's the public can't read your private contract because it's now sealed. It's a sealed record.
okay. So he had another question that he asked, or not a question, but a statement more so. It's saying that the supreme law of the land is presumption. Affidavit of corporate takes you out of the public from the beginning so that you can't be presumed your corporate entity. So, what is your thoughts upon that? I mean, is he making any valid, in your opinion, is he making valid statements? I think I know what he's trying to say. So, I mean, but
I know what he's trying to say, but this is what I try to tell brothers: they need to go back and read minimum contacts. Minimum contact. They need to understand where they create a minimum contact. They need to understand that because if you use the Federal Reserve notes, you just created a minimum contact.
okay. So, what about the affidavit of corporate denial? So, if he files the affidavit of corporate denial, that's what he's saying. I remember those affidavit of corporate denials back in the day. What, in your opinion, if he files an affidavit of corporate denial, how is that putting him back in common law?
It depends on. I don't know what he's doing. See, I do everything by contract. An affidavit. What is an affidavit? As me and you know, it's a form of witnessing. That's all it is. It's a form of witnessing. It falls under the rules of evidence. It can be listed as discovery material. It can be based on, facts. You know what I'm saying? So I like to use contracts and then support contracts with affidavits to say that we like in the contract. I spell out what we're doing. You know what I'm saying? Because a contract I think it has more validity than an affidavit. You see what I'm saying? Putting in just an affidavit, the affidavit can be challenged. Because an affidavit can be perjurous. But when you look at a contract, now we got to determine if this is a valid contract. We got to start looking at elements to determine if this is a valid contract, to look at the elements of a contract versus then looking at if this an affidavit. So I like contracts better than affidavits because a contract, especially if it has a notary attestation to it, it is going to have a lot more validity because now it's binding upon the two parties. If I just make something, if I make a statement in the affidavit, that don't make nothing binding. I just made a statement. In those statements, anything I say can and will be used against me. So, but if I got a contract, the court can look at that and and see how that works a little more better in association with an affidavit.
All right, I got you. I'm here. I hear you. So I'm looking up. This is not necessarily the affidavit I'm familiar with. I've seen affidavits of corporate denial like back, I don't know, man, probably about 10, 15 years ago. But this is an affidavit of corporate denial form instruction. So I mean, it's dealing with the U.S. codes, and it seems like it has it's coming out of. Now this is what is this? It's coming out of. See, this is the Sovereignty, Education, and Defense Ministry. So this is something that they kind of put up together, right? So affidavit of corporate denial. If y'all want to look at that, y'all just type it in. Affidavit of corporate denial. A sworn statement is a declaratory presentment to the judicial branch of the United States, the IRS, Social Security, of a firm and complete denial that I, the affiant, the living soul, have ever, with full knowledge and intent or awareness, saying voluntarily through written consent or constructively by my actions, consented, agreed, or accepted any government benefit, privilege, or entitlement that might result in the surrender of my constitutionally guaranteed rights at any time. Okay, so, all right, that right there. I mean, that's kind of what they, talk about. What, in your aspect, do you see that being beneficial? I mean,
Hold on, Chief. I'm trying to pull up something.
okay. And brother Bay, I'm not necessarily like against or against what you're saying. We're just trying to like put it out there and elaborate or break it down. You understand what I'm saying? So uh I understand, like, it's clear. I mean, like, so let me ask you this, brother, since you're there. Uh, is this an affidavit that's similar to what you might have done? Because if we're discussing it, I want to know if this is something similar, or uh, what exactly would be different in than what this contract or this affidavit is saying versus the one that you're talking about. Because I'm not here to sway away one way or the other. We're just making clarifications. Okay. So with that being said, let me go back into this. So
I was trying to pull up the contract for the religious, and I'm just trying to look for it and see if I can pull it up. I
that's
thought I
cool.
would. So I'm,
While
I'm
you look that up, while you look it up, I'll just kind of go through this because I'm, like I said, the brother has made a point. We're on here talking about these things, so I really want to break this down. And he's saying it's simple. It's plain and simple. I'm not saying it's not simple, but for the sake of the video, my brother, we are going over it. If that makes any sense to you, you understand? Because everybody may not be aware of this or, um, you know, understand it. You got to have some kind of back legal understanding to deal with this. So basically, it's saying this affidavit of corporate denial. To me, it is a contract, King. When I'm looking at this, I mean, it's an affidavit, but it is making some contractual agreements. So it says that right here, number 2. It says agree to act as an agent. So this is something that is not part of. It's not part of agent, contractor, or officer for the United States. A federal corporation as defined under U.S. 28 USC 3002, Section 15A, or any of the subordinate business entities, such as the Social Security Administration or the IRS.
Those are just statements. That's not a contract.
Well, I'm not. I get that they're statements. I haven't gotten through the whole thing yet. It says agree or presented to be treated as an officer corporation under any of the following: 26 USC 6671B, 26 USC 7343, Federal Rules of Civil Procedure. Agree to be treated as a public officer engaged in trade or business, which is defined under 26 7701A 26 as the function of a public office. So I'm reading this. I mean, you see this. So what is your opinion on what we're looking at, and how is this, in your opinion, is this a valid, comprehensive way to put yourself back under common law?
No. Affidavits can be challenged.
Okay.
So let's say this. Let's say you got a driver's license. It already states that you're a part of selective service. The court is going to look at everything. If it pull up and it show that you still have an existing status with the selective service, everything that you said just flew out the window. You're making a whole bunch of statements. Versus if I put you on a contract and I say that you cannot act as an agent or principal of another, upon this agreement, that if you do such thing, it would be deemed void, and that the person would make an error and may be liable for acting in such capacity. But under his religious sincerity, he cannot act because he vowed all his earthly possessions to the Most High and shall follow the pillars of Islam or whatever religion that he's going to follow. He's on a contract. That's different than saying I'm not this and I'm not that. I got a contract to prove that make me binding to a religious institution that practice this. That's a difference.
So you saying that the contract is stronger than the affidavit?
I'm saying that an affidavit can be challenged. I'm saying if I was in my legal position.
So the affidavit, so you're saying that the contract is stronger than the affidavit. Now, I'm gonna let you deal with that when you get back, but I think from what I hear you saying was that if you already contracted to these different agreements, and then all you're doing is making a declaration or a statement trying to void all that, you can't just void it by doing that because you don't know the stipulations.
You got to rescind the contract. You got to rescind the contract. You got to go through the protocol associated with the contract to give you to say you have under the rights to rescind it. So you can't just say this. You got to then, by operation of law, they tell you how to rescind these contracts. You got to understand by the operation of law, give them back the contract. Now the contract become void because you discharged the contract by rescinding it based on what they gave you the instructions according to the law on how you get the relief for rescinding the contract, versus them making a whole bunch of statements about what you're not. Now you got evidence that you rescinded the contract and that the contract itself is proof.
Okay. Shay, check. Islam. All right. So let me ask you this. With that being said, okay, so the brother was saying this has nothing to do with religion, which I understand that this is all like not necessarily religious. However, I don't know if this actual document, the Copyright of Sovereignty, Education, and Defense Ministry, that may be a religious entity that created this document, even though this document is not talking about necessarily religious.
Hold on. It used the word ministry.
I know. I'm saying it's saying, yeah, it's using the word at the bottom of the page. It says affidavit of corporate denials, copyright, sovereignty, education, and defense ministry. Now, I'm not saying that this is the brother's one that he used. He said it was something similar. So his may not have anything to do with religious affiliation. But what he's saying is that this has nothing to do with religion. Now, what you are speaking of is based off of religion. Can you tell me why it may be more important to deal with it from the religious side versus just what we call the sovereignty side?
Because the contents of the First Amendment says religion. The substantive language in the Constitution under the First Amendment says that the Congress can make no laws to prohibit the exercise of religion. It's a prohibition on Congress. Congress can't make no laws. It didn't say nothing about the state. It just said Congress can't make no laws to prohibit the free exercise of religion.
So, especially Brother Bay, if you're using the term Bay on your name, that is dealing that goes back to some religious institution. Because if you're part of Moorish Temple of America or any of these affiliates, they're dealing with religion because you're dealing with a prophet. Okay, you're dealing with certain religious principles. So to me, it would be more advantageous for you to bring your religious belief and creed into the document along with all that, because you're going to be able to invoke more constitutional power, in my opinion. So I don't know. You tell me, brother. You tell me, King of Bay.
I mean, when we're so Bay is associated, even with some would say nationality, some would say with the Moorish science. You see what I'm saying? So it's based on a premise of a particular people and their culture and their belief system, right? Which could be customary associated with their belief thinking, religious belief.
Right. What I'm saying is, Moorish Temple of America is a religious organization, and it was Noble Drew Ali, which was under the religious guise that he set this up. Now, I understand he had set it up previously under civic, but his final institution was a religious institution, and that was for a purpose. Okay, so what I'm saying is all of us who are Moorish Americans are coming under some type of stipulation. Now, let me ask you this, my brother. Do you have any do you consider yourself any religious entity? Do you, as a Moor, do you consider yourself Islamic? Do you consider yourself any of those things? Because, being Moorish comes under some type of religious, it's not just a political status. Even though I understand what you're saying. I mean, because it can hold political, but it also has religious undertone in it. So, when we're dealing with this, if we're going to bring up these documents and we're going to try to present them to court and things of that nature, I think what King Abe is saying is that when you bring that religious part to it in court, it validates the documents even more because it's under religion, and they really don't have any authority to impede on your religious documents, right? But as if the document is just standing on itself, it doesn't have any religious connotation to it. It does, to me, in my opinion, leave you a little bit more open for scrutiny on your documents in court. Now, I'm not saying that you haven't been able to use them successfully or any of that, and I'm not here to attack, but we're just trying to bring clarity and bring more remedies to it. So I love it, brother. I love this dialogue we got going. It's saying that the UCC wasn't here when Noble Drew Ali was alive, and the UCC truth can only be established by affidavit. All right, my brother. I got you.
I'm trying to get where brothers getting these principles from. I'm trying to understand the stuff because when you look at the UCCs, they talk about negotiable instruments, and most negotiable instruments are what? Contracts. We talking about contracts, man. Contracts. So I keep trying to tell people affidavits. When you file an affidavit in the court, it don't do nothing. We talking about contracts. Contracts gonna have a more heavier punch than a affidavit. We talk about when you under the selective service, you're under contract. When you are under a BMV, you are under contract. They don't say no
Right,
affidavits. They say
right,
you're under contract. Now you can use a notary to authenticate the contract, but it's still a contract. I don't care which way you want to say it. So we're talking about contracts. Affidavits ain't nothing but, as you know, a form of witnessing. It can be looked at as almost a statement or a deposition. We need to understand the legal foundation so we can stop saying things so that we can better appropriate ourselves with understanding the legal mindset. I would rather use a contract to hold you more binding to a situation than an affidavit.
Hmm. I got you.
If I got proof that you owe me $5,000, if I sold you a car, am I gonna use an affidavit or am I gonna use a contract to bind you? I might support that contract with an affidavit, but am I gonna use an affidavit? I'm gonna state that Bentley owed me some money. I gave him a car, or I'm gonna put Bentley on the contract to say I gave Bentley this car. Here's the terms and conditions for payment of the car, and utilize the contract to hold Bentley responsible for what he needed to do and perform under this contract. Which one is you gonna use, Chief?
I understand what you say. I mean, he personally contract. I mean, contract is more. It's been used. It's binding. They using contracts. They use so many contracts against us every day that are binding us to these rules that we're under, regardless if we got an affidavit or not. But I'm not saying that we wouldn't use an affidavit because I do use affidavits as well as contracts.
But what will come first, the contract or the
Uh,
affidavit?
now the brother is talking. So I mean, and I do this too, brother Beck. Getting the contract notarized is what makes it an affidavit. Now, what you got to say about? Because me and you had that discussion a while back. Because I was saying that too. What is your
Contract notarized?
yeah?
No. So that's I try to. This is why I do what I do.
I
Okay.
know, brother. That's why we got you here,
So
brother.
okay. So yeah, you can get a contract notarized, and you know what I'm saying.
Okay,
But
for sure.
what we looking at, the court is going to determine if it's a valid contract, whether it's notarized or not.
Right,
They're going to make a determination on the contents of the contract, right, before they say anything about it being an affidavit. Because truthfully, you have a contract that's notarized. What's the purpose of notarizing? The notary is witnessing off, saying, okay, this person did this. But if the court look at this and say this is not a valid contract, I don't care if you got that contract notarized or not. It ain't gonna stand as a contract.
right. Right. So, I mean, but now my question is, would it be stronger as a contract affidavit? Wouldn't it be make it more binding? I guess,
No,
or no?
no. What you want to do is see. This is what I'm talking about when you understand the contract. Just getting it notarized. No, when I get my contracts, I use notary attestation. Why do I want to use a notary attestation versus just getting the document notarized? Because the notary is going to look at and verify the content, showing that both parties appeared, agreed to this contract. She's going to attest to certain facts. And then she's going to notarize that because she's attesting. What is attestation? She's making a statement. Now she's going to notarize it, verifying that the stuff is in the contract based upon the two parties. She's doing a notary acknowledgement, attestation, or something in the form so that now you can use that once you get it, even if you get it authenticated, it makes it more powerful. Why? Because the notary saying, I witnessed the two parties sign the contract, here's the contents of it, this is what I read, this is what I know about the contract, and then she notarized it. Versus then stamping it and saying this is notarized, she ain't put nothing with it. She ain't made no statements with it. She ain't said nothing. Now, when we look at this, now we can rely on what the notary eyeballed and seen. She's going to say, well, I looked at this. This is what I read, blah, blah, blah. Got it done.
Got you. I got you. I'll say. So, my brother, I got another statement up where he's saying a corporate entity can't speak, which is true. And then it says, I reserve the right to not contract with fictitious entities.
I mean, that's a right. He has a right to do that. But
Exactly.
let me ask you this. What is you going to the store spending? What is you utilizing? Is you using gold? Because the system that I know takes Federal Reserve notes. And if you don't understand how that, so with the IRS, what they gonna do? If you don't know the tax language, if you don't know particular language, like we use the word donation, how did you come in possession of that money? Did you find it? Did somebody give it to you? Did you work for it? Where's the transaction that can verify how you receiving the monies? You got a job. If you got a job, you talking about you ain't contracting with a corporate entity and you got a job. Come on, let's make this make sense. We have to now look at the things in the scopeability of everything and put it in the proper context. This is why I'm saying we say things because we don't understand the legal ramifications because we don't identify with everything necessary. I've been doing this too long to I know how to shape my mind around all of these different variations and circumstances dealing with these issues, dealing with these legal determinations, right? You got to understand you got to know the law, know the legal system, and you can say that, yeah, I have a right to reserve that, but then you go to work every day and got a social security number. They don't care about you making no affidavit and saying that. They're going to treat you accordingly to what the contract you under.
Right.
They're going to impeach what you just said, tear up that affidavit. We don't care about that affidavit. They ain't doing nothing for us. We see you still under contract. This is why I keep trying to tell people, affidavits is cool, but I know how to use affidavit to the scope of evidentiary evidence. But I'm rocking with contracts all day, every day, baby.
I got you. I'll say. Hey, well, I feel like that's a lot to deal with, man. I think we did cover. I think we covered common law, statutory law. in regards to modern day times, and I hope you guys got a better overstanding of these concepts of common law and statutory law. If you have any questions or you guys have anything that you want, please contact us with the number on the bottom of the screen. Please, you can also check out indigenousmoors.org, and you can contact us that way. And please, y'all, since y'all in the building, please like this video. Please like the video. And if you're not a subscriber, please subscribe. And please share this video. If you guys felt like it was entertaining, please share, man. And definitely, man, I definitely appreciate the build. Peace and love to you, brother. I mean, we all here to learn, and nobody's against each other. We're all learning. So you guys, everybody's got something to contribute to this this thing we're doing here. You know what I mean? So much love, appreciate everybody who's donated any monies. We appreciate all the help that we can get, and definitely.
I would like to say this: there's no such thing as a stupid question, my brothers and sisters. Ask. I'm not here to. I'm only here to educate and rise the people, help the people elevate. So, as my brother Kuno said, he got hope. It stands for help my people elevate. So when we understand what's going on, my job is to give the people proper information, proper instructions. I ain't never against nobody. This is not a challenge. I'm just telling you I've been doing this for a long time. I'm good at what I do. You see what I'm saying? On the basis of me walking in the courtroom, I could talk my stuff. He didn't see me do it. He didn't challenge me like, hey, man, I went through my growth and development, walked in the courtroom. Now I know how I do a better job at handling the court than I ever do in any legal situation.
Check. Yes, sir. So
peace and love to you.
Yep. Appreciate everybody. Peace and love. And you can catch us on the next episode of Pro Se Moors 101. We out. Tuta Nana. Peace.